Okay, all, let's chat a little bit about teacher rights. All right? Teachers are in schools, they're adults, they're citizens of the United States, they are entitled to certain rights under various constitutions and statutes, and yet they are also employees of the school district. And that turns out to be a delicate balance between their rights as citizens and your role as public employer. All right, so let's take a look at a few different areas of teacher rights, and I think you'll get a sense of it. Let's start with the First Amendment. Okay, the First Amendment has a few different provisions in it, but expression is the one that comes up most frequently with teachers, although certainly religion can come up and assembly can come up for political reasons. But expression is where the action is, and there's a lot of action here with teachers on expression issues. So prior to 1968, no free speech rights for teachers. Teachers were just terminated at will by school boards, but like many other things, like you should be sensing a theme at this point in the class that the 1960s really changed everything when it comes to our understanding of what citizens can do in schools, both for kids and adults. So 1968, we have Pickering versus the Board of Education. This is a case just outside of Chicago. A teacher writes a letter to the local newspaper complaining about how the school district is spending their tax dollars on some new sports thing. You know, this is a total space for teachers. This is a normal thing for them to do. Like, hey, I need the money for my academic program. Why are we building another football field? Totally understandable, right? So that letter to the editor goes to the newspaper, gets published, and the teacher gets fired. Now, prior to 1968, hey, this is no problem. You don't really have rights. But the teacher files suit, goes all the way to the Supreme Court, and the Supreme Court puts in a balancing test that tries to balance the citizenship rights of the teacher versus the employment rights of the school district, and they ask those top three questions there. Does the speech jeopardize a relationship with the superiors or coworkers? Does it impair the teacher's classroom performance, or does it substantially impede school operations? Does it hurt the school in some way? If you answer those yes, generally, okay, then we're going to go ahead and regulate the teacher. If you answer those no, generally, okay, cool, then we are going to let the teacher say what they want. Superb. In 1977, we get a little clarification. It turns out that teachers took this way broader, and even if they were totally capable of being terminated for some other reason, they would always claim some free speech thing. So the Supreme Court got involved again and said, whoa, if there are valid independent reasons to fire this teacher, we're going to disregard the speech issues that might be involved here, okay? So the cases, when they come for teachers, they need to be purely about speech. That needs to be the real motivating factor for the employment decisions. In 1983, then the Supreme Court got involved one more time and said, hey, wait a minute, a lot of the stuff the teachers are saying is stuff that's complaining about themselves and their own jobs. What we're only really interested in protecting here are things of public concern, matters of public concern. Okay, so something needs to generally concern all of us, not just concern a private grievance that teacher has. Like if that teacher's complaining about her pay or his pay, that's a private grievance. That's not a matter that the whole public cares about. But how tax dollars are spent on sports facilities, that's a matter of public concern, and that's something then that the Supreme Court would protect. Okay, see how that packages up nicely? Okay, that was the law of the land from the 1980s on. Worked pretty well, that basic balancing test. Then in 2007, the whole game changed. Okay, almost a decade ago now. That whole existing framework, which you can see above there, a whole new test was put in front of it. So if you think about this as a flowchart, the Supreme Court then got involved in 2007 and put a test on the front end asking whether or not the speech was pursuant to the official job duties. Okay, so this case, the Garcetti case, emerged out of the like local prosecutor's office context. It wasn't even a teacher context. Nevertheless, it got applied to teachers over time as public employees. And the Supreme Court in 2007, this was a conservative Supreme Court at the time, really took a step back and said, hey, whoa, we need to give the employer in this situation a lot more ability to regulate their employment context and take some rights away from teachers when it is something that is core to their job as a teacher. So if something is pursuant to an official job duty, whether or not it's a teacher or the custodian or the secretary up front in the office, all of our school personnel, if they're speaking as part of their job, then none of this applies. None of it is protected. There is no constitutional protection in their core employment responsibility. So you can see that we sort of went back to pre-1968 thinking about the role of teachers, in that their role as employee is primary, and as employee, the employer is permitted to regulate their expression. All right? When the teacher is not functioning really as an employee, okie dokie, then the whole Pickering balancing test can come back into play, and we can sort of balance those rights. All right? But this was a massive change to how we think about teacher expression. From the position of school administrators, this is a good thing. It gives school administrators a lot more freedom to regulate their staff. All right? So, I know a lot of you are not in that position yet of being a school administrator, but someday you might find yourself in that position, and you'll see then when, as the employer in this scenario, you have a lot more flexibility to regulate teachers. All right, on we go then. So now listen, we got a problem here. We got a problem, which is how much are we going to let schools regulate teachers out of school behavior? We're certainly going to let schools regulate teachers' behavior in their job as teachers in the classroom, but teachers are public employees, and we sort of hold teachers to a higher standard. Remember the whole EPSB, Professional Standards Board teaching standards? We hold teachers to these higher standards. So when teachers do sort of dumb things in their private lives, can we punish them for that? Yes, as you can see there. So when private conduct becomes notorious and it's directly beginning to affect their performance as a teacher, then school boards are allowed to step into that situation and take negative employment actions against them for their private behavior. This is somewhat different than all other industries. All right, most other industries, you work at a factory or something like that. When you're at the factory, we're going to regulate your behavior tightly. But when you go home, you do what you do. We don't really care. As long as you show back up at 8 a.m. the next morning and you work your butt off when you're here, people don't care. But that's not what we do with teachers. Teachers have to be held to a higher standard throughout society, and we sort of come to that conclusion because they're working with young, impressionable youth, and as public employees, remember, they are the state. To the kid, the teacher is the law. The teacher is the state of Kentucky. We expect them to not do really dumb things out about when they're not on the job. Okay, so let's take a look at what that looks like. So there's really not a lot of rights to protect here. All right, I want to talk about the Fourth Amendment in just a second, because that's a search and seizure one. The Ninth Amendment gets interpreted sometimes as a privacy amendment. It's a really weird amendment, actually, if you want to go read it. It's probably the weirdest amendment that we have. And then the 14th Amendment, of course, the due process protections in the 14th Amendment sometimes can help protect teachers. But really, there is no right to privacy in the Constitution. Okay, that has broad-ranging implications on all kinds of different areas of society, including, for instance, the government's ability to search your cell phone, right? There is no constitutional right to privacy that's clearly articulated. Anyway, so what that means for teachers, though, is that their private lives are really not all that private. And schools do have quite a bit of ability to get involved in their private lives. All right, so that's sort of what lays the groundwork. Let's take a moment to look at the Fourth Amendment and search and seizure. And the search and seizure laws that apply to kids that we learned before also sort of apply to teachers. There is certainly more ability to search, both as an employee and as a teacher that's trusted with young children in society, okay? So we do not expect school officials to have probable cause before they conduct a search on a teacher. And of course we do all kinds of things, like you can see there in the image of even having drug dogs go sniff teachers' cars and that kind of stuff. That's all, of course, perfectly viable. What is somewhat new over the last decade or so is sort of the rise in suspicionless testing of teachers. All right, so you remember back to the search and seizure rules for kids, we demanded individualized suspicion in order to conduct a search on a kid. But for teachers, particularly teachers that we deem to be in sensitive roles, which a court here in Kentucky, as you can see, it's in the module, has determined teachers are, those people that are in particularly sensitive positions can be subjected to suspicionless searches, including drug testing. All right, so maybe a lot of you took a drug test when you took the teaching job, so that's not going to be new to you, but that is a search. You know, certainly it is a search. I mean, think about what is being searched there. So that type of suspicionless searching has been permitted with teachers. I will say, though, practical guidance to you principals, I wouldn't make it a matter of habit to just be conducting randomized searches of your teacher's possessions. You're not going to have a very strong culture in your building if you go for that. Nevertheless, the courts have given you quite a bit of flexibility here with teachers. Okay, now sort of back to privacy, back to the 9th Amendment, the 14th Amendment, and teachers' lifestyle choices. We'll talk more about this when we're all back together, but teachers have been fired for just unbelievable things. You wouldn't believe it. Here you can see several of those that have happened over time. 2003 was a real turning point for us, I think, as a country. You know, teachers prior to 2003 were very regularly, I think, getting fired for homosexual conduct, certainly, but also some of the other stuff on that list, like pregnancy out of wedlock and adultery. The Lawrence v. Texas decision, though, which is just an absolutely mind-blowingly fascinating opinion out of Texas. 2 gay guys were caught having sex, although they weren't really having sex. It's just a really fascinating endeavor. Nevertheless, the Supreme Court in that case said, hey, whoa, wait a second. There are some limits here on how far we are going to allow the state to get involved in people's private lives. And what happens in the bedroom, this is going to be private. Okay, so the Supreme Court came out for privacy in that instance. And since that time, I think you really notice in the country, in schools, a real pulling back on the desire to try to regulate teachers' behavior out in their personal lives, which I think is a good thing. Nevertheless, it certainly still happens, and school boards certainly still feel that they have the ability to regulate teachers' behavior from time to time. For instance, let's say teachers at a local bar gets a little tipsy, embarrasses him or herself a little bit, and a board member happens to be there at the bar, right? That's going to be talked about, right? And there's going to be a conversation that happens with that teacher, and you, principal, future principals, might be the person that has to have that conversation. It's still happening, and the courts have permitted some regulation of teacher behavior in those private spaces. It does have to become disruptive in the school. There's got to be some rationale. But if that rationale can be made, then actually school boards still have quite a bit of authority to regulate teachers' personal lives. I know, weird, crazy. For many of you that are still teachers in your career, this is not an awesome module. I apologize. Remember, though, you may want to be principals soon and think that entirely flips the script. Now you're the employer, and the lesson from this entire space is In this period in our history, we are pretty pro-employer as a school. That may well change. New Supreme Court appointments, and we might go back to more of a 1960s approach. But for now, we're pretty pro-employer with teachers. Thanks for watching.